Investigation and Appeal, matter 56 Fellows Road Limited and ABC Block Management Limited.
Mr. Kessler.
Thank you. My Lord, I appear for the appellant, my learned friend Mr. East, for the respondent. This is an appeal about two payments. First, I'm going to call the June payment, which was made by Mr. Wolanski to an account directed by Mr. Fishik on the 15th of June 22. We say that the June payment immediately discharged the judgment debt owed by the appellant to the respondent, even if Mr. Fishik, DCBL, and Mr. Williamson subsequently misappropriated the payment. As a consequence, we say BC is not entitled to obtain the interim charging order the following year. As I understand the respondent's position, it's that the June payment could have discharged the judgment debt because it was made by Mr. Wolanski's personal account and not a corporate account. It did not. And the circuit judge held slightly different reasoning, which is that Mr. Fishik was not an agent of the creditor, and that was, according to her, a significant part of the district judge's error at first instance, contributing to his finding the debt had been discharged. That's
Just pause there. Is there really a distinction between the 2 points? I mean, the money definitely came from Mr. Wolanski's personal account. If the money was paid by Mr. Wolanski with the authority of the company as a payment on behalf of the company, then it is discharged the debt.
yes. Yes, there is a part of the circuit judge's reasoning that relates to the question of whether or not an enforcement agent is a creditor able to receive, enforcement agent is an agent able to receive funds. That relates to an argument made at first instance that's not, I think, being pursued in my learned friend's skeleton argument, but it does make its way into the circuit judge's reasoning, as I'll show you shortly. So I think these are slightly distinct issues. That's the June payment. The second payment is the October payment, which is the transfer of the same sum of money, just short of £10,000, by DCBL to Mr. Wolanski on the 12th of October, pursuant to a settlement agreement. And we say the settlement agreement forms separate consideration to compromise Mr. Wolanski's personal complaint. The circuit judge held that the October payment was further reason that the judgment debt remained unsatisfied, because it was indicative of Mr. Wolanski's capacity at the time. And I think the respondent's argument is that since the money has been repaid, it is impossible now to ratify the payment. And as that summary indicates, the respondent doesn't address the court in its written submissions on the grounds of appeal as I advance them, and instead it stands by its respondent's notice, which raises a slightly narrow issue about authority, whether a director has authority to permit themselves to pay a valid debt on behalf of the company, or whether there's been ratification. I plan to address the court unless you want otherwise on the basis that I have two targets. I have the decision of the circuit judge, which is phrased slightly differently, and I should address it on the arguments in the respondent's notice. The structure of my submissions will be as follows. I'd like to begin with the law that governs payments made to enforcement agents acting under written control, and then I'll make submissions about the June payment, and then I'll make submissions about the October payment. So, I'd like to begin with the 2007 Act in the Authorities Bundle. Tab 5. Section 62 provides that Schedule 12 applies when an enactment writ or warrant confers the power to use the procedure in that schedule. And in subsection 2, we have an example of some enactments, writs or warrants, and in particular, the power conferred by a writ or warrant of control to recover a sum of money, ... is exercisable only by using that procedure. So if there is a writ or warrant of control, we have a writ, one must use the Schedule 12 procedure. The other point to make about section 62 is simply a matter of definitions. For a writs of fieri facias, except certain ecclesiastical writs are renamed writs of control. So if you see the writ of FIFA, that is now considered a writ of control. Moving ahead, I'd like to show the court 3 paragraphs of Schedule 12. The first is paragraph 2 on page 19. Paragraph 2, only an enforcement agent may take control of goods and sell them under enforcement power. So paragraph 3, an enforcement agent, if he is not the person on whom the enforcement power is conferred, may act under the power only if authorised by that person. So thinking ahead, we're going to see the enforcement power is conferred on Mr. Williamson as High Court Enforcement Officer. He then authorised Mr. Fishick, who was the enforcement agent who attended 56 Fellows Road. Paragraph 50 is at page 22. Paragraph 50 is quite central to our case. Proceeds from the exercise of enforcement power must be used to pay the amount outstanding. And it's central to our case that enforcement agent has no discretion in the use of the monies. The monies must be paid under the waterfall created in paragraph 50 with reference to the regulations. I won't take you through the waterfall, it doesn't matter. The only point is that the language is mandatory. And the last paragraph, Schedule 12, is paragraph 66. Next page, which creates a statutory claim available to debtors in the event of a breach of the provision of Schedule 12 or acting under a writ that's defective. Now, the remedies are wide, but there are two specific remedies mentioned in subparagraph 5. A, the return of goods, and B, an order that the enforcement agent or a related party to pay damages in respect of the loss suffered by the debtor as a result of the breach. And you can see from subparagraph 7 that that's without prejudice to any other powers of the court.
Is there learning on whether goods includes money?
Yes. Goods include money. The definition of good, I don't think I gave you because it's in subparagraph 1. It's probably to be found in my Lady Justice Elisabeth Lang's decision in Bone and Williamson. Essentially, it's assets of any kind. Let me find it. I can't see it in Bone and Williamson. Whereas it's argued in CS and Marsden as well. In the context of paragraph 50. If I take you to, just to answer my Lordship's question, tab 15, page 95. And at H is paragraph 95. Confirms that includes money. Paragraph 96, the arguments made by counsel that must be physical money, and that's rejected by Lord Legate.
So far as it has any relevance, when we come to paragraph 66(5)(a),
yes,
that includes money.
That includes money.
Yes, I see.
And the relevance, just thinking ahead a moment, is that there is a mechanism under which, if Schedule 12 is breached, the court can order the return of the goods, and in so doing, the court can make, for example, a declaration saying the judgment debt is outstanding, the judgment debt is extinguished. That's the court on that application under paragraph 66. What I'm going to say is that can't be done by way of contract between the parties. Parties can create a contractual debt, they can't create a judgment debt. And so I really am jumping ahead. The settlement agreement under which the October payment was made couldn't possibly undo the effect of the June payment. That's where this is going. There wasn't a paragraph 66 claim here. There was a complaint under the certification of enforcement regulations. There's a point about, you'll notice that 5b, in the context of damages, says the court may order the enforcement agent or a related party to pay damages. And the 6th related party is either the person on whom the enforcement power is conferred, here it's the HCO, or the creditor. And this court held in Burton and Ministry of Justice, the liability of a creditor is strict, i.e. the creditor doesn't have to cause any loss. It's enough that the enforcement agent has caused loss for them to be liable in damages. Vicarious liability. And the consequence of that, I say, is that if you read paragraphs 50 and 66 together, payment to an enforcement agent must satisfy a judgment debt. And the reason I say so, sorry, my lord.
Well, give your reason.
The reason is because if the creditor still has this outstanding claim against the debtor, because the judgment debt hasn't been satisfied, but if the enforcement agent has been paid, which is the scenario we're thinking about, there's been payment to the enforcement agent, they haven't passed it on, there must be a breach of paragraph 50. There must have been a breach of Schedule 12, and that is actionable by the debtor against the creditor. So let's say, give numbers, £100 is given to the enforcement agent, the debt is £100, it's been misappropriated, then if payment to the enforcement agent doesn't satisfy the judgment debt, then there would be a claim of £100 in one direction and a claim on £100 in the other direction, equal and opposite. And that doesn't make sense.
Can I take another sort of example? So suppose that an enforcement agent, for some unknown reason, goes to somebody with absolutely no connection to the debtor.
Yes.
At premises having absolutely no connection to the debtor.
Yes.
But the debtor is frightened and hands over some money, but immediately asks for the money back, and the enforcement agent hands it back. What's the position then?
The debt would be paid. The enforcement agent doesn't have the power to hand back the money. That's clear from paragraph 50.
Well, let's suppose it all happens on the same day, on the same occasion. I hand over £100.
Yes.
And then I say, look, this is ridiculous. I don't owe this money. It's got nothing to do with me. I'll have the £100 back, please. Can the enforcement agent return it?
Not without an order of the court. I would say no. Now, I can see a situation where if you're thinking of cash, £5, £20 banknotes, you might argue as to whether or not the enforcement agent ever had the proceeds of the enforcement power if he only had the banknotes in his hands for a couple of seconds. It's quite different from the situation here where payment is made to a bank account by way of an electronic transfer. But that could have been transferred back on the same day. So I see your lordship's question. The analysis then becomes slightly complicated. It's not obvious what, having discharged the judgment debt, you might think there'll be some sort of scope to recover the money from the debtor again, that suggests directions as sought.
So just to be clear, where somebody unconnected with the debtor makes a payment,
yes,
the debt, you say, is necessarily discharged.
Oh, sorry, I thought in your scenario, my lord, the debtor turned up, was surprised and scared. You know, the third party was surprised and scared.
Yeah, the third party is surprised.
I think you said the debtor.
Oh, did I? Sorry.
Yes.
In that case, it's no good as an example. Sorry, the enforcement agent turns up,
Yes.
somebody entirely unconnected with the debtor.
Yes.
I'm coming to what I meant the example to be, not the John Prescott type example where words mean whatever. So the person with absolutely no connection with the debtor hands over £100.
Yes.
and then says it's ridiculous. I've got nothing to do with the debtor. I'll have it back, please. Can the
Yes.
enforcement agent return it?
I suppose the question, it might turn on the circumstances of the payment. And if at the first instance the third party intends to satisfy the judgment debt, then we'll see this in the case of Crown Trade. We'll have to start thinking about claims against the original, the true debtor. If, on the other hand, they pay it under duress, say, this is only temporarily yours to get out of this problem, this enforcement agent is at my house and I have nothing to do with this, then they can get it back from the debtor. And the reason they can, get it back from the enforcement agent, and the reason is because the enforcement agent has no lawful power to take control of anyone else's goods. They can only take control of goods of the debtor. That was...
Can I just explore those for a moment?
Please.
You say, well, if the third party,
Yes.
intimidated,
Yes.
hands over the £100,
Yes.
then if the third party intends that to discharge the debt,
Yes.
it does discharge the debt.
Well, I suppose there'd be a question about whether he was making the payment with the authority of, and not with the / ratification of the actual debtor.
And
That would be a further
suppose that
nuance.
there is no authority.
Yeah.
So this is a person entirely unconnected with the debtor.
Yes.
The £100 is handed over. Does it discharge the debt?
It would not due to the laws of enforcement agents, but due to the laws of making any payments on behalf of the third party.
So this is what I'm just trying to be clear about. On your case, when the £100 is handed over,
Yes.
is the debt necessarily paid because of paragraph 50, regardless of whether the debtor authorised the payment? Or does the question of whether the debt is discharged turn on whether the payment was authorised by the debtor?
It will turn on whether the payment was authorised by the debtor, with the exception of unless the debtor is themselves. This can happen involuntarily. That it often does. An enforcement agent comes in, takes the debtor's stuff, takes their goods against their will. That's the whole point of an enforcement agent.
Yeah, no, quite.
But if a third party voluntarily makes a payment, this can be seen from the passage of Chitty cited in Circuit Judge's judgment, that doesn't discharge the
Now,
debt.
I entirely follow the sense of that, but in that sense, it's not suggested that the statutory scheme in some way overrides the ordinary law of contract.
No, I'm not suggesting that.
No.
What I'll argue is that a company director has authority.
Which obviously is the case. The question is whether the company director exercised the authority.
Yes. And I'll argue it's difficult to understand how he couldn't have done, given that he was the one making the payment.
I mean, I'm taking you out of your course, but
Yes, I will come to that.
if the payment is made by somebody who is a director intending to make it on behalf of the company, albeit from his own money,
Yes.
so that the debt is discharged, you couldn't ask for a chargeback, could you?
Well, I'm not actually aware of the schemes for chargeback, but no, I think I can't comment. I don't know enough about how a chargeback works, my lord. I noticed a reference to chargeback in the evidence admitted on Monday, but I can't comment. I think that comes to the law of banking, which I wouldn't want to address you on.
Yep, okay.
What I will say is that if someone is unhappy about what an enforcement agent does, they aver that they've acted in breach of the schedule or acting under a defective writ. Paragraph 66 gives them a mechanism as a debtor. It's a bit more complicated for the third party, actually, but as a debtor, they can make a complaint and get an order that the money is repaid.
So you say it's a bit more complicated for someone who isn't the debtor.
I do. Unfortunately, paragraph 66 only applies, subparagraph 3, the debtor may bring proceedings under this paragraph. And a complication in the Act is that there is no equivalent to paragraph 66 for a third party. It's actually quite common. It's scenario the Lordship posited to me a few moments ago. It's quite common that an enforcement agent turns up to the wrong address, possibly because the debtor has moved.
Yeah.
Someone else is living there, and the enforcement agent doesn't believe them when they say, oh no, Mr. X has left the premises, I'm Mr. Y. And then the third party pays. And how the third party gets that back is, I think, an interesting and live question. It may be under the general law of unjust enrichment. Fortunately, the court doesn't need to decide that today.
I just wonder about that. I mean, so you want your money back. Who do you ask for it back from?
You would sue the HCO, the High Court Enforcement Officer, if you are the third party. If it's a physical good, like a Ming vase, then you would seek an order for delivery up, and that would be against the person holding on to the good. But the money ought to be held. I'm just coming to this point. The money, cash money, ought to be held in the HCO's bank account, and that's why they're the correct respondent/defendant.
Yeah.
If an auctioneer is holding on to the goods, you'd have to bring payment to the auctioneer. That's a nice segue onto discussing HCOs, which is a slightly different High Court Enforcement Officers, four-letter acronym, I'm sorry. It's a slightly different statutory creature. They don't have the power of an enforcement agent. They are required to appoint one to enforce a writ of control. They're responsible for their conduct. That was discussed in detail in the decision of Bone and Williamson. There's one particular detail, I've already alluded to it, but just so you can see it in the regulations. Fact about High Court Enforcement agents is that by virtue of Regulation 8, this is at tab 3, subregulation D, they're required to hold a bank account through which money is recovered on behalf of judgment debtors are to be collected and paid. And this court, in Bone and Williamson, I could take you to it, but I think it's clear from the face of the regulation, held that HCOs must therefore be the parties holding the money. So we don't know quite what happened here, but what ought to have happened is that Mr. Fishik says, pay an account, and that account is an account in the name of Mr. Simon Williamson. Bone and Williamson, which incidentally is the same Mr. Williamson, criticised Mr. Williamson for not complying with his obligations. So, I've argued why paragraph 50 and 66 read together suggest that payment to an enforcement agent must immediately satisfy judgment debt. Completeness, it's worth observing first that this was the common law before the Act, and secondly, I say it follows as a matter of the law of agency. There I disagree with the circuit judge. So, on the common law before the Act, turn up at tab 8, decision of Wood and Finnis. And it's a case about a different writ, a writ of case A, capias ad satisfaciendum, which is a writ that no longer exists, fortunately, but it requires a sheriff to imprison a debtor pending payment, and on the facts the debtor paid the sheriffs. Now, the case A law isn't relevant, but the relevant part is comparison with a 5A at page 33. It's the highlighted passage where Baron Park contrasts the duties of a sheriff, now an HCO, enforcing a case A versus a 5A. Makes it clear that in the latter case, that of 5A, the defendant is discharged by payment to the sheriff.
Can we? Which bit should we read? Where do we pick it up? Do you see the line on page 33? Yes.
I would begin from, in that respect, his duty upon the case say differs from
His being.
the sheriff's duty.
So let's just understand that the sheriff's duty upon the, however it is case A, differs from that under 5A, by which the sheriff is directed to make a sum out of the goods and chattels of the defendant and himself to have that money at the return, so that in the latter case the defendant is discharged by payment to the sheriff,
Exactly.
and the sheriff becomes debtor to the plaintiff.
Yes. Because they have a duty to account for the monies they received. That's not true for a case A, but I'm not going to address the court any further on that writ. That takes me to why would this be the case? And I say it's a simple application of the laws of agency. Settled position in Chitty that payment to a properly authorised agent is payment to the principal. I don't think I need to take you to Chitty. What's the question is, does that apply here? Is, in this respect, an enforcement agent / HCO a true agent of the creditor for purposes of receiving monies? In support of that submission, helpful to start with the writ. It's in the supplemental bundle, tab 3. So it's a standard template. The writ is addressed to Simon John Williamson, enforcement officer, authorised to enforce writs of execution from the High Court, and it creates 2 commands. The first command is a command to seize and execution the goods, chattels, and other property of the claimant authorised by law, and raise therefrom the sums detailed in the schedule, fees and charges, and immediately after execution to pay the defendant, ABC Block Management Limited, the said sums and interest. And the second command is to endorse the writ. Fine.
And just going off on a red herring for a moment.
Yes.
The address given is Flat A, 56 Fellows Road.
Yes.
And that wasn't the registered office of the company.
Correct. That is an address provided on the application.
Yes, I see. And that therefore is provided by ABC Block Management.
Exactly. Yes. I think it's an evidence that the DCBL applied for this writ, which would be the standard practice. Well, perhaps more common for the HCO too. But either way, the typical procedure is the enforcement agency deals with the formalities, getting this sort of application. But the application is of that of ABC Block Management Limited. You see that at the bottom of the page.
So the application is made by ABC,
Yes.
but you hypothesise that the enforcement agent was involved with identifying the address and helping with the filling in of the form.
Yes, I think that's right.
Yes, I see.
I think I'd be a bit more precise. I'd hypothesise it was DCB legal, because this would be without raising Missouri issues. I would say the conduct of litigation would encompass the application for a writ of control. Let's not go there.
Yes,
But,
I see. Yes.
And actually, if you look at the right-hand column near the top, the address is for enforcement R, Flat A, 56 Fellows Road, London,
yes.
W3. So that supports what? Yeah. Okay.
Yep.
But the key point is this is made on the application of the creditor. It's not something unilaterally issued by the court
No.
to enforce its own judgment. So ABC said to the court, please give this power to Mr. Williamson. Just parenthetically, on this command, I think on either side of this debate, it must be common ground this command is not been followed. We say it's not been followed because immediately after execution, Mr. Williamson didn't pay the defendant ABC Block Management Limited. That's why we say he's in breach. I think ABC would say Mr. Williamson is in breach because he hasn't obeyed this writ of control, which remains outstanding. We say it's been satisfied, but on their case, it remains outstanding for many years. So that's why I say agency relationship is created. It's because ABC has, by this application, authorised Mr. Williamson to execute its judgment debt. That can't happen spontaneously. And Mr. Williamson authorised Mr. Fishick. We know that from paragraph 2 of Schedule 12. And so I say, in this respect, Mr. Williamson and Mr. Fishick are ABC's agents and sub-agents. The circuit judge would disagree and say that's inconsistent with CS and Marston. I'd like to turn to now. This is behind tab 15. Decision of Lord Legate just after his appointment. And what happened, the facts of this case are that there were two writs being executed in parallel, and the question was which writ receives priority? Is it the first to be issued, or is it the first to be effective? That's the argument. Is there a race in these issuing creditors, or is it one at a time based on issuance? And an argument made by counsel was that if you look at paragraph 15 we had just now, it says the enforcement agent must pay the amount outstanding. And the amount outstanding, they say, must be the amount outstanding under the writ. Which writ? Their writ. So the argument made was it should be whoever gets there first because of paragraph 50. And if you turn to page 92, we can see what Lord Legate made of that argument. In paragraph 79, Lord Legate said it might be irresistible if the enforcement officer to whom writ of control is directed and any other enforcement officer agent authorised by the officer act under the power conferred by the writ were no more than an agent of the creditor to whom the sum recoverable under the writ is owed. If that was so, the only duties owed by the enforcement officer would be the duties owed by an agent to the principal. It would be inconsistent with those duties to require the agent to pay anyone other than the principal proceeds from exercising on the principal's behalf, power to recover the sum of the principal. And then paragraphs 80 and 81, the critical ones, I'd like the court to read them.
Yeah, I'll do that.
So, the key words I'd emphasise are, Lord Legate says it would be wrong to regard enforcement officer to whom British control is directed simply as the agent of the creditor. And then in paragraph 80, quoting Lord Cranworth LC, Hooper and Laing, Sheriff, though for some purposes an agent of the party, not a mere agent, public functionary, with duties analogous in many respects those of an agent towards the principal, but he also has duties towards others. So what we say from this is not that Lord Legate is saying that there isn't a true agency relationship, it's that the agency relationship must be understood that the High Court enforcement officer and enforcement agent has supervening duties owed to the court. A bit like, an analogy has been made before, a solicitor who's an agent of a party, but also an officer of the court, and there are certain instructions which the solicitor will not make on behalf of their client. They won't perform them because they're unable to due to this supervening code. Much like a solicitor won't make a vexatious or spurious claim, so too an enforcement agent will have to pay the first creditor, first meaning that the creditor whose writ of control is issued first. It's part of their duties to the court and the administration of justice. But this does not mean, and cannot be read as saying, that an enforcement agent is in no way an agent of the creditor. They are, for some purposes, an agent of the creditor.
So they're, as it were, an agent plus.
An agent plus. And I think it goes without saying that the duties an enforcement officer will owe to the court do not prevent them paying their client, paying the judgment creditor. That's the whole purpose. That's why the court wants them to act. That's the command. They can't not pay their creditor. The writ doesn't say, pay the creditor if you choose to. Now, with that in mind, I'd like to turn to the June payment. If you have questions about the legal background. It would be helpful to address you on the circuit judge's judgment. It's in the core bundle. Just, you'll note I've been addressing you in quite the sequence the circuit judge gives her judgment on. Paragraphs 29 to 33 about agency. The district judge very much had it in mind that payment to a enforcement agent would be good discharge because of the agency reason, and the circuit judge disagrees. I think I've addressed you on why the district judge was right. On the June payment, if we go earlier in the judgment, back to paragraph 16, which is on page 60. The first point made in this paragraph is that the district judge does not have sight of all of the evidence. I should say it's a bit of a refrain in this judgment. With respect, we don't agree with the emphasis the circuit judge placed on the evidence in this regard, because we say this is a case where the facts are basically common ground, the fact of the June payment, the fact of the October payment, and the question really is the legal interpretation of those facts. Sorry.
I have to say I do wonder about that, because there seems to be a key factual issue as to whether or not Mr. Wolanski, when he made the payment from his bank account, was authorising that as a payment by the company.
Well, I have 2 points to make about that. I have a procedural one about that. That's not how the argument's put at the first instance.
Do you mean in front of the district judge?
In front of the district judge.
The whole thing in front of the district judge seems to be in a muddle.
Well, you can see the submissions, and the district judge had written submissions in front of him, and they were about agency. If I take you to the supplemental bundle, tab 12 is the skeleton argument on behalf of the defendant. And if you go to the analysis section, first, the challenge is that of ostensible authority. And there are various reasons why Mr. Wolanski's argument cannot possibly be correct. Claimant has not paid the underlying debt to the defendant. Mr. Wolanski has paid the sum of £10,000 to a bailiff firm called DCBL, which subsequently returned the sum to Mr. Wolanski to settle its debt with Mr. Wolanski. Debt owed by the claimant to the defendant therefore remains due and owing. The argument made before the district judge was, you just paid the wrong person. You can't just pay an enforcement agency. You've got to pay the debtor. Sorry, you've got to pay the creditor. And although it was a short judgment, sometimes I wasn't quite sure if the judgment was given in submissions or in... By the way, the district judge rejected that analysis, that much is clear, and said, no, when you pay an enforcement agent, you are paying the creditor. That's a procedural argument that says this is all a new challenge brought on appeal.
And I see how you put that. If one assumes that it's open to
Yes.
the now respondent to say, well, was the payment made on behalf of the company?
Yes.
What was the evidence on that?
Let's look firstly at the payment receipt.
Well, that's what the enforcement agent thinks is getting.
Yes.
Did Mr. Wolanski say he'd authorised himself to pay it on behalf of the company?
Mr. Wolanski says, if you look at Mr. Wolanski's witness statement, which is behind tab 11,
Yes.
he uses the passive voice in paragraph 6, the judgment debt was paid in full.
Which in one sense is obviously true, because that amount of money was paid in full. Does he say he authorised himself to pay it on behalf of the company?
Well, he says 16A, the judgment debt is settled in full by the claimant. The claimant being the company, 56. I have some, we're going to come there in more detail shortly, but I have some issues with the idea that there seems to be a presumption under the respondent's case that there needs to be some formality for authorising yourself. I simply don't agree. There doesn't need to be a board meeting to decide outside 56 Fellows Road should the debt be paid.
I mean, we'll obviously work through the evidential matters in a moment.
Yes. So, I think I was addressing you on the circuit judge's argument. Wrong, apologies, a judgment. Circuit judge's judgment at paragraph 16. And she observes that district judge now cited all the evidence, and then she recites some paragraphs of Mr. Innes's witness statement. And Mr. Innes said, claimant maintains the judgment debt was paid in full. Enforcement agent Craig Fishick, and he attended flat A, 56 Fellows Road, 15th June 22, being the personal residential address of Samansky. This is accepted. So the case is put forward by a witness on behalf of ABC, is that there was full payment, but it was undone by the October payment. And you can see that in this next paragraph, having reviewed the complaint made by Ms. Wolanski internally. DCBL took a commercial approach to offer money paid by Ms. Wolanski in the sum of £10,000 odd to be returned to him. So it's an argument about the October payment. It's saying there was a June payment, that would have been good discharge, but for the settlement agreement, there would be nothing to go on. And I think that must be right. And one of the peculiarities of this lack of authority argument is that if it works, then Mr. Wolanski is owed £10,000 odd.
Well, I'm not so sure about that. But anyway.
Because the money would, the money would have been paid, it wouldn't have been authorised. It hasn't been ratified, that's the argument made. So it must be sitting there, subject to the October payment.
Well, as I understand the respondent's case, it's the other way round, isn't it? They say, well, the money was paid and returned. Mr. Wolanski is where he ought to be. It's just that you still owe the debt. Yes,
but if you break the link between the two, as I plan to, and say that the October payment can't possibly be related to the June payment, then the money would be sitting there. June payment would be affected.
I mean, I see that in theory.
We'll come
I
to
don't
that.
suppose that that was how the people repaying the money saw it.
Well, again, we'll come to that, because
Yes.
that comes down to the construction of the settlement agreement.
Up to a point.
Well, yes. Either way, let me return to. We'll come to the settlement agreement. So let me park that thought. circuit judge has just recited Mr. Innes's evidence, and then paragraph 17 referred to a payment receipt. It may be worth just briefly looking at the payment receipt. It's in the supplemental bundle. Behind tab 3, wrong, behind tab 4. And it shows a payments made by debit card, 15th of June. Cardholder name Simon Wolanski, because it comes from Mr. Wolanski's personal account. If third party, what is the relationship to the defendant, director? And the circuit judge said in paragraph 19 that the reference, the director, clarification as to his relationship to the third party.
And is the authorisation code, is that the claim number that the writ related to, or is it something completely different?
Sorry, where's the authorised? Oh, I see, yes.
Down at the bottom?
Yes. Yeah.
I don't know, because I just asked the question, I haven't checked.
I do not know the answer to that question, my lady. It is not the same as the writ number.
It's not the same as the written number.
But
So it may just be an internal administrative
it may be.
matter. Thank you.
The writ number, I think, is case ref at the top left. It's very blurred, but you can slightly see the
Oh, I see.
HCW, which is High Court writ.
Okay, so that's the written.
Sorry, I've got lost again. Where are you?
Very top left-hand box under payment receipt. It says case ref, it's very blurred, and then there's a very, very blurred.
Yeah, I see.
That's DCBL's internal case ref, but you can see it on the writ of control at the bottom.
Yeah.
It's following the previous page on the application of ABC Block Management Limited, and then there's the HCW High Court writ. It doesn't surprise me that that's printed, because I thought this would have been generated in advance, and completed on the day in handwriting. So, the district judge has said that the statement of director is merely seeking clarification as to his relationship to the third party. And then the judge cites evidence in paragraph 20 saying that, to the effect that Mr. Wolanski made the payment in fear of the impending break into his flat, and concludes on his own evidence the respondent was paying the debt in a personal capacity. Now, it is obvious that when you're making a personal payment, you are making a payment in your personal capacity, because you have what is capacity? Capacity is, in this context, and I've reduced the definition in Jowett's, so it would be helpful. Maybe I should look at the definition of Jowett's in that interest in the authorities bundle.
Just so we know exactly where we are, what the judge is quoting is the document at...
is the complaint DCBL. At page 8 of the bundle, tab 5, supplemental bundle, tab 5. This is the certification of variations complaint.
So this is the complaint. This is the 15th of June.
Yes. It's the certification regulations create a different regime. We've looked at paragraph 66 in some detail. There's a different regime for making a complaint about enforcement agent. In effect, it's the objective of such an exercise is normally to make sure the enforcement agent loses their certificate, but the court has the power to order compensation. Maybe I should take you to that regulation.
So just to understand, I mean, assuming what Mr. Wolanski says about the visit is correct, and there's no particular reason to believe it isn't correct, then I can well understand why he was so aggrieved.
Yes.
And on the very same day that the visit happens,
Yes.
the visit is at 8 o'clock in the morning, and later that day, he puts in this complaint.
Yes, I'm not sure if that complaint was made on the 15th itself, or if that's just the date of the incident.
So if you look at page 7, it's got a date of the 15th.
Yes, it has that date. I wonder if that is the date of the incident or the date of the. Only because it's a little surprising it would be the same day, not impossible, but. Yeah, I get back to you.
Yes.
Oh, I'm instructed it was the same day, so there we go.
I see, yes. Very good.
I was opening the authorities bundle again. I think I referred to 2 points. I should take you to both. I said that this was a complaint under a different regime. That's behind tab 6. Regulation 9, certification enforcement agent regulations, allows any person to make a complaint. There's no fee for such a complaint. And then over the page in page 11, from regulation 11, says the premise of this is that High Court enforcement agents have a bond of £10,000, and that the judge may, if satisfied the complaint is well founded, order the security of the bond to be forfeited, whole or in part.
Yeah.
So and that's the complaint that we just looked at, which was dated 15th, and made on the 15th. I also, I think, briefly referred to what do we mean by capacity in the context of the judgment, and I thought it's helpful just to look at Jarrett's definition behind tab 21. It's the last page of the authorities bundle, page 161. It's quite a good definition. If you have different functions by virtue of different responsibilities.
Sorry, where are you reading from?
The capacity, page 161.
Oh, 165, I'm on the wrong page. Yes. Yes.
So in this context, Mr. Wolanski has responsibilities to the company and powers that are vested in him by virtue of his office of directorship. And that's what you mean when you say the capacity of being a director. Now, his ability to access his own bank account is not by virtue of being a director. It's in the personal capacity. And so the circuit judge is quite right to say the respondent was paying the debt in a personal capacity, in the sense that this can only have been an act of him personally, because it's personal funds. Where she's wrong is to say, and that means it could never have been a corporate act at the same time. I think I was addressing you on that was paragraph 20 of the circuit judge's judgment. We're on page 62 now. Paragraph 21. 21 notes that the company couldn't have paid anyway because it had no cash. It had to be Mr. Wolanski's personal funds. 22 says, respondent sought to persuade me that ECBL should have paid the appellant. However, they could only do so if they had received the monies from 56 Fellows Road. Now, pausing there, that's obviously an illusion of what's to follow, but plainly a third party can pay a judgment debt voluntarily. You can see that by way of illustration from the fact that the payment receipt has a line that says, if third party. It must be relatively common for this to happen. But I don't think it's right to say they can only do so if they've received the monies from 56 Fellows Road. But the qualification is what matters. And it's the citation from Chitty on Contracts, early edition. Doesn't really matter.
It's got a bit garbled, this, actually. If you read it literally, it doesn't quite make sense. And if you compare it with the actual version of Chitty, it's not quite the same. I mean, the thrust is the same.
The thrust is the same.
Not quite the same.
I should say, please.
So the point is that the debt isn't discharged unless there's been prior authority or subsequent ratification.
Exactly.
And that's one of the ways it's garbled, because where it says require authority, it's prior authority, I think.
Oh, that may be the transcription error rather than the judge's.
Yes.
Yes, but this, I should say this principle is not in dispute, so we don't need to look at the authorities behind it.
So on the face of it, the key question in the case, well, at least on one view, a key question is, when Mr. Wolanski made the payment from his own bank account,
Yes,
was he authorising himself to make
exactly.
the payment on behalf of the company?
Exactly. And there are two elements of that. First, the question of did he have the power to...
And he obviously had the power.
He obviously had the power, and the question is did he exercise the power? I won't address you on the fact he had the power in that comment. What would it mean if he failed to exercise power? I say that the very same act of payment of the company's debt was itself authorization for the debt to be paid. It's bizarre for someone to say, I didn't authorize myself to act the way I actually acted.
Well, he
highly unmeritorious.
certainly authorised himself to pay it on his own behalf. The question is, did he authorise himself to pay it on the company's behalf?
Yes. But what would it mean if he didn't, I suppose, is the question.
It would mean that he could ask for the money back, complain about the enforcement agent, ask for a charge back.
Yes, and I think it would be quite an unmeritorious argument to try and get the money back on account of him not authorising himself. Really, his complaint was there's been a breach of Schedule 12 here. The enforcement agent has gone to the wrong address, threatened to take control of the wrong goods, personal goods, not corporate goods. That's his complaint. And about the conduct of the enforcement agent vis-à-vis his son. His complaint is not that the company never authorised this to happen. There is the point about formalities. I think my submission is there are no formalities required for this sort of authorisation, which is why the very same act of payment can satisfy both. Let's just turn the tables here. Subject to the point about the October payment, if the money hasn't been returned, I'm going to argue why it can't have been, then the money would be sitting, it ought to be in the HCO's account, it probably isn't, we don't know. Mr. Wolanski will personally be entitled to claim against ABC for unjust enrichment on the grounds that 56 FRL never authorised the payment. And surely that claim would be entirely unmeritorious, because the very same man who says he wasn't authorised to act is the only person able to give himself that authority. So that is all I wanted to say about authorisation. Ratification is best dealt with after discussing the settlement agreement.
So in other words, if the debt was to be settled, it could only be settled by a human being. And I mean, what inference do you draw from the fact that the sole director of the company pays the money.
I'm not sure I fully.
No, well, I'm just rambling, so perhaps ignore it. Don't worry, I'm just sort of thinking aloud.
But let's come back to it.
Yeah.
Maybe my confusion. I was going to address you on that's the June payment. Now on to the October payment.
Yep.
It's the settlement agreement. It's in the core bundle. On tab 16. That's the second ground of appeal. The judge urgent thinking the analysis changed as a result of this agreement. And as we see in the analysis of the first instance, the argument of the first instance was that this somehow undoes the June payment. June payment was valid but for this. And the argument now is there can now be no ratification but for this. So let's look at it from the top to bottom.
I mean, in terms of the law,
Yes.
if indeed this involves, supposing, contrary to your case, that Mr. Belansky had made the payment personally
Yes.
and not on behalf of the company, and the money had then been, well, putting it differently. So suppose Mr. Belansky makes the payment personally, not on behalf of the company. It's then open to him to ratify it on behalf of the company
Yes.
at any point up to the point that the money is returned.
If it had been, yes.
If the money is returned, it ceases to be possible to ratify it
Yes.
after that date.
Yes.
Yeah.
I agree with that. The question would be, does this return the money? I know it uses the word returned. We're about to discuss that.
Yes.
If in the absence of this authorization application argument, in the normal case, I would say that a settlement agreement can never undo the payment of a judgment debt. I've alluded to this earlier. Charging order can only be granted in respect of an order of the court, and the parties can only create a contractual debt. They can't create a judgment debt by consent. So even if this settlement agreement said in explicit language, due to the breach of Schedule 12, we are returning the money, the judgment debt remains outstanding, I would still say there couldn't be a charging order, because the judgment would have been extinguished on the first payment, and the parties can't agree to do that. They have to go back to the court and seek an order. For example, on paragraph 66 application. But that's not, I say, what this instrument tries to do. It's an agreement between Mr. Wolanski, whose name is the debtor. I think that's just an error. We all agree that he's not the debtor. And DCBL. DCBL, firstly, shouldn't be holding on to the funds. You know that from Bone and Williamson.
I mean, to be fair, you'd asked them to hold on to the funds, hadn't you?
No, I don't think we did.
We go to supplemental bundle. No, they're supplemental bundle.
Sorry, are you on the first supplemental or the second?
I'm on the second, the recent supplemental bundle.
In which case, I haven't studied this thoroughly, but please.
If you look at page 9, an email of the 16th of August.
Yes.
Mr. Wolanski says, I confirm that if the chargeback isn't successful, I'll be issuing a claim, blah, blah, blah. In the event that this is the case, please can you confirm that you will continue to hold the funds until such time as the court hearing is concluded, and that you will not be sending the money to ABC.
Mm-hmm.
So you have been asking them to hang on to the money.
Yes, or at least not to pay ABC. The point I was making is going to be about the HCO. And I'm not sure Mr. Wolanski says, please can the enforcement agency hold the funds, not the HCO hold the funds. It's not quite what I understood this to be. His point is don't pay the creditor.
Yeah.
But as a matter of law, DCBL should not be holding on to those monies. We know that from Regulation 8. Bone and Williamson. The other point is that DCBL doesn't have the authority to return the monies. Only two people have the authority. One is ABC, and the other is Mr. Williamson in respect of his fees. Fees belong to Mr. Williamson. So I can see how Mr. Williamson could say, yes, he can return that, but DCBL cannot. So, agreement terms. The first clause obviously uses the word returned, which obviously suggests the money is being paid back. But I say that given that DCBL ought not be holding on to the money, it has no power to return the money, that can't be taken at face value. And to repeat Mr. Wolanski's submission below, I do say that sloppy drafting, i.e. it is not determinative of the legal effect of the agreement. The second clause requires Mr. Wolanski to immediately withdraw the EAC2 proceedings. We've looked at those. Those were brought by Mr. Wolanski personally, not the company. And that's not surprising because complaints really are Mr. Wolanski's complaints. They're about my property being taken, my son being convicted. The third and fourth clause are where I pin my argument. DCBL in the third clause confirms as part of this agreement there will be no further High Court enforcement attendances made at 56A Fellows Road. Now, DCBL can't ignore command of the court. The only construction that can be given is that this is acknowledgement that the writ is satisfied. It's fallen away because the money's been paid. That's the only possible reading, lawful reading, paragraph 3. And the same is going to be true for paragraph 4. Agreement is in full and final settlement of the matter related to the High Court writ with the reference and the county court claim. Parties agree no further recourse to be sought by either party. Now again, DCBL can't compromise a writ. They can't compromise someone else's claim. What this is recognition that there is no claim left. It's effectively a recital. And the recital is the effect the money's been paid. There is no outstanding writ, there is no county court claim anymore. It's all been tied up. Those are the two most important clauses, just to wrap this up. On the receipt of the payment, withdrawal of the EAC2 proceedings, confirmation of the court of the same. The matter with DCBL with reference HCW stands closed. That's the writ number. I think this refers to the internal complaint, I'm not sure. That's clause 5. There is no clause 6. Clause 7 is a no admission of liability, and 8 and 9, confidentiality and a choice of laws. So wrapping this up, I say that this, as a matter of principle, the contract can't create a judgment debt on which to found an interim charging order. But this agreement certainly doesn't even try to. DCBL has no authority to do so, it's just an enforcement agency which provides Mr. Fishik's services. It can't take any steps under Schedule 12. It would be in breach of paragraph 50, as we've seen, to agree to return funds. It expressly compromises both the writ, thirdly, and the county court claim, clauses 3 and 4. That only makes sense. The judgment is acknowledged to be paid. And fourthly, it's a small point, the question of whether that's commercially realistic, given that Mr. Wolanski is compromising a claim. What does he get? He gets just the money back, because the creditor can still enforce the judgment. One final observation about settlement agreement. This is not an agreement. There is no indication in this agreement that the repayment is due, as Mr. Wolanski is making an unauthorized payment on behalf of the company. It's not saying, in the absence of any ratification, authorization, we are returning the money to you. If DCBL had thought that, one moment, as officers of the court, they would have been obliged to return the money unconditionally. It's not open for them to say, here's money that hasn't been authorised by the company that you want back, we're only giving it back on these conditions that you compromise your claim. That's not open to an officer of the court. I'm not sure it'll be open to anyone. The premise of this agreement is that the June payment discharged the debt. And so I say that this was not the return of the monies. I have severed the link between the June payment and the October payment. And if I'm right about that, monies haven't been returned, then the analysis, and it relates to the ratification argument, that the money, as of today, ought to be sitting in Mr. Williamson's bank account. It's probably been misappropriated, maybe by DCBL, we don't know. But they are holding on to it, and they have a present obligation either to pay ABC in compliance with the writ, or to return the money. And I say my client even today is able to give ratification. I'll go a bit further. I'd say that the very filing of the application to set aside the interim charging order is ratification, because it's an application made by the company saying that we have paid this debt. When do we pay it? When Mr. Wolanski paid it, in June 22.
Sorry, I wasn't keeping it up properly. The filing of which document?
The filing of the application to set aside the charging order. Application is slightly strong because it's not made in N244, it's read by letter, but it's been treated as an application.
And that was which date?
And that was I don't think the letter is dated. It's at page 20, tab 8 of the supplemental bundle. Page 20.
Might be dated in the index.
I don't think it is. I just checked that too. It's not dated in the index because it's not dated in the letter. But it's something after receiving notice of the interim charging order in July 23.
One thing you do see in that letter,
Yes.
in the middle, is it says to settle the matter and induce me to withdraw the complaint, the bailiffs agreed to refund the monies.
Yes. You're using the word refund rather than pay.
Is there a difference between refunding and repaying?
Well, I wasn't sure if your Lordship's point was this connects it to it is repaying money that they received in June payment.
Yes, I mean, you're saying,
that was
well,
the point.
The settlement didn't involve repayment of the money that they'd received.
Not properly so called.
Mr. Wolanski says, well, they agreed to refund it.
Yes. I'm not sure his language can be considered determinative, my lord. The question is this a refund properly so called? Indeed, refund isn't even a term of art. The question is the legal effect of the October payment? If June payment was valid discharge, and I say it is, or even if it wasn't, and it was held in abeyance in this non-authorised, non-ratified world, is the effect of the October payment to undo either one?
So just, I think we've both gone through this already, but just
Yes.
so I'm clear in my mind. First question, did Mr. Wolanski authorise himself to make the payment on behalf of the company at the start?
Yes.
Supposing that he didn't, it remained possible for the company to ratify that payment, certainly up to the point that the settlement agreement was concluded.
Yes.
If the money was returned at that point, then it ceased to be possible
Yes.
to ratify. If, on the other hand, it wasn't returned at that point, then there definitely has been ratification since, either by this document or by the express ratification that we see in the
supplemental bundle, yes, exactly. Yes. Exactly. Which would be open to the company to do at this point, because the money hasn't been returned
yes.
in the meaningful sense. Unless anyone has any further questions.
No, I don't detect any. So thank you
Thank
very
you
much,
very
Mr. Kessler. Mr. East.
My lord. suppose the best way to start this is to say that the respondent's reasoning in opposing the appeal broadly mirrors the reasoning that was employed by Lord Justice Newey when he was granting permission, and that reasoning can be seen, I'm calling it the core bundle, page 65.
Yes.
May I draw the attention of the court to the second sentence of the first paragraph after the heading specifically, where it states, "It is true that A cannot pay B's debt to C without B's consent, but if B accepts the payment, meaning authorises or ratifies it, there is no reason why a third party cannot discharge a debt owed by someone else." I think actually in the submissions and the questioning, matters have caught up with us somewhat insofar as that's accepted, and of course the respondent accepts that position. But of course what the respondent says and asks the court to take heed of, it's the emphasis of the authorisation or the ratification. And then if I return to the reasoning that underpins the permission, in the same paragraph, starting with the sentence in the middle of that paragraph, where Mr. Wolanski was the sole director of the company, and the payment was intended to remove the threats of enforcement, it is not difficult to infer, and I emphasise the word infer, that he intended, in his personal capacity, to discharge the company's debt, and he, in his capacity of the company, accepted that payment as a discharge of the company's debt, and thereby authorised or ratified it. So the court's pinned the concept there, and very much in the same way the respondent asks the court to consider what it means, therefore, to be able to have come to the conclusion that there is the inference that authorisation or ratification has taken place. This isn't in the authorities bundle, but it just came to me whilst I was preparing. So far as I just used the words of Lord Justice Neuberger in Stack and Dowden, 2007 House of Lords case, when concepts of inferred intentions are considered. Whilst not directly applicable, it's helpful when he says that an inferred intention is one which is objectively to be deduced to be the subjective actual intention of the parties in light of their actions and statements. And so Mr. Wolanski, as the sole human mind behind the appellant, is the person to whom the court may think is the appropriate individuals to consider what their actions have done, what they have stated, the documents that they have presented, how can the inference be drawn. So I invite the court to consider the chronology of the interactions between the parties. The first date to consider is obviously the 15th June 2022, when the High Court enforcement agent attends. I can invite the court to look at the first supplemental bundle, and it's at page 7. We have what's commonly being referred to as the EAC2 complaint, and it's been questioned as to what date this was filed. The date in the bottom is the 15th of June 2022. I believe Mr. Wolanski on instructions now confirmed it was made on that date, but it can also be seen in the main body on the right hand side that the question to be asked is details of the complaint, include details of when and where the actions took place. He says at the very top, 15th June 2022, it took place, but there can't be any living between the date and when this complaint was filed. And if the court turns to page 8, this is the continuation of the complaint, and considers the second from last paragraph. It goes towards the end of the first sentence, I should say. I then felt my only option was to pay the funds, arrange to pay the funds from my own personal account, which has nothing at all to do with the debtor. And obviously the emphasis there is on the phrase which has nothing at all to do with the debtor. The respondent says that that is relevant because it shows that at the time that the payment was being made, Mr. Wolanski was not of the opinion that he'd made the payment on behalf of the debtor, and that the payment, in his words, had nothing to do with the appellant. The next relevant date to consider is the 20th of June, so 5 days after the attendance. I invite the court to consider page 23 of the second supplemental bundle. So before you now, you should have an email from Mr. Wolanski, dated 20th of June 2022, timed 3:20 in the afternoon, title 2 complaints and subject official complaint, notice of enforcement. This is the complaint made to DCBL. So he's going through their internal complaints policy at this time, and it's 5 days after the enforcement. And it can be seen, one goes about midway through the page, there's a short paragraph, a single sentence. It says, the enforcement officer unlawfully enforced the debt, which was in the name of 56 Fellows Road Limited, against me personally. And the second from last paragraph, the first sentence begins with, he said that none of this mattered and that I had to pay myself now. Of course, the emphasis is on pay myself. And then finally, on the 20th of June, if the court turns the page to page 24, you'll see the first 3 paragraphs effectively say what was going on at the time. It tells us that he was in fear of having his goods taken away, his phone was taken. He says in the 3rd paragraph, 2nd line, I felt I had no other option than to make a payment personally, which I then did. The relevance of that document again is to say that 5 days after payment was made, the inference that can be drawn, really the only inference that can be drawn, is that the complaint is being made on behalf of Mr. Wolanski on the basis that he has personally made this payment. He isn't making a complaint simply about the conduct of the attended enforcement agent.
Are you leaving that document?
I'm leaving that document now.
Just before you do,
Doing
3 paragraphs from the end.
If this is dealt with me swiftly and full funds were taken from me returned, I will close the matter. I was going to come back to that document, but now we've seen it. It's a slightly different position insofar as the continued use of returned, and the court's already picked up on the use of refund and the word or the interpretation of what the settlement agreement means. It simply goes towards that point.
Yes, so sorry, I was taking out of your...
No. I'm grateful, my lord. Because my submission on that point will simply be what has not been paid cannot be returned, and a person who has not paid something cannot have it returned to them, or an entity, as it were, and that's the normal course of the language. The next relevant date will be the 28th of June 2022, with 13 days after the event now, and it can be seen, the document I wish to take the court to is at page 2 of this second supplemental bundle that we're on. This is actually a letter from DCBL to Barclays Bank, dated 28th of June, and it's in relation to the chargeback notification. And I asked the court to consider the reference in the top right hand corner, your reference, not our reference. It ends in UN22. The relevance of that reference is that there is a second chargeback application. Once this one apparently fails and is defended, the second chargeback application comes and there's a different reference number. What it says is, I write to you further to the chargeback notification that was received on 21st of June 2022, confirming that a payment of 966 spot 56 has been charged back by the cardholder. And doesn't seem to be in contention that the cardholder was Mr. Wolanski because he's made the payment from his personal bank account. So the person who has instigated the chargeback is apparently Mr. Wolanski in his personal capacity, because he's dealing with his personal funds.
I mean, I suppose who else could make the request?
Yes, I'm not sure I can go too far into that because we haven't got the evidence about the bank account details, and I've taken the learned friend's point. I don't know enough about the chargeback process or even what happened in this specific instance to make submissions on it.
Yes, I see.
I simply say it appears that Mr. Wolanski has made this, and whilst he would have to make it, if that's the case, that only the cardholder can make the chargeback, it simply goes further towards he is taking steps to recover what appeared to be his personal funds.
But the implication of DCBL's response is that what they did was perfectly lawful, and that that's an answer to the chargeback notification.
Yes, that was their defence.
Yes, all right.
I accept that. They make exactly the same defence. It's almost a copy and paste when they make the second defence in respect of the second chargeback, which I'll take you to briefly. So the next relevant date is at the 10th of August, and that's at page 4. And again, it's the letter to DCBL to Barclays Bank in respect of the second chargeback. The relevance only is that there's been 2 attempts to make this chargeback on the card.
But just before you get there, there's a similar point is made in the email of the 8th of July, isn't it?
It is, yes.
So DCBL again saying we acted perfectly lawfully.
Yes.
Under the authority of the writ.
Yes, I can't deny that. It's exactly what it says. Or
Yeah.
if it doesn't say that in exact terms, I
Well,
can't
that's
define
in
exactly
essence.
what it means.
It's in essence what we're saying.
Yes.
Isn't it?
So we fast forward to the 15th of August. It's in the supplemental bundle, page 6. Now, this is a correspondence directly between DCBL and Mr. Wolanski.
When you say supplemental bundle, we're still in the
Second
second supplemental bundle.
bundle, yes. So at this point, DCBL's speaking towards having undertaken its own internal review of the complaint. It talks about the chargeback that was successful. But if one turns to page 7, turns towards the second from last paragraph, talking about the second chargeback. Halfway through that paragraph, third line starts with, if the chargeback is unsuccessful, DCBL have confirmed that a gesture of goodwill and informed final resolution of the matter, a refund of the enforcement fees will be made, and that's £2,166.
Just going back to the 10th of August letter,
Yes, my lady.
Mr. East, again, the position being adopted is that we've acted perfectly lawfully, and there's a slightly confusing reference to the defendant in the penultimate paragraph. Upon the visit, blah, 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 the defendant agreed to make full payment using a third-party payment link. Copy of the receipt provided to Mr. Wolanski. So DCBL seem to think that the defendant and Mr. Wolanski are two different entities. DCBL also note the defendant has confirmed in writing that they paid the funds following the visit from the agent. Not quite sure what that means. All necessary steps were taken as per regulatory guidelines in relation to the sealed High Court writ.
I'm not sure I can make any comment upon that, really,
No.
other than to say I accept that the defence at the first instance, which may be expected in circumstances where people are challenging monies, which I would suggest is commonplace when a bailiff has attended and payment has been made, was to simply say that compliance has been there has been compliance, and that the monies have been lawfully obtained.
Yeah.
May I return to page 6? So sorry, actually we're looking at page 7 of the letter, 15th of August.
Yeah.
So the first issue is there's, at that point, 15th of August, there's discussions about making payments from DCBL to Mr. Wolanski in resolution of the complaint. Well, actually, what's being referred to is the matter. And I say the matter is the complaint. And if one looks slightly above in that paragraph, it says, following a conversation with a colleague, it's the second line, you have confirmed, that would be Mr. Wolanski, that if a chargeback is unsuccessful and the money is returned,
Is successful.
apologies, then the complaint will be resolved. Pray for the Lord. So again, I say when they refer to the matter, it's always known that we're talking about the complaint, and the complaint is emanating from Mr. Wolanski. And then follows a succession of quick-fire correspondence between the parties over a number of days until September. And the first is at page 9. And the court previously asked, or made comment that Mr. Wolanski himself had asked for DCBL to retain the funds pending the outcome of the issue between them. And we will see that several times reiterated by Mr. Wolanski in this interaction. So from the second from last paragraph, starts in the meantime, I can confirm that if the charge is not successful, I will be issuing a claim in the county court for the full amount that was charged plus interest. I reserve the right to recover any losses in relation to this dispute and the visit by Mr. Fishwick. Mr. Fishwick was the enforcement agent. And so I say he's speaking there about recovering the monies in his personal capacity, because he's talking about a complaint that's being made in his personal capacity. And it would be difficult for, let's say, the appellant to potentially bring some kind of claim in compensatory damages against Mr. Fishwick, who seems also to be the focus of a potential claim, or at least Mr. Fishwick's actions. That would have to emanate from him in his personal capacity. And then, as can be seen, 16th of August, last paragraph, he requests confirmation that the funds will continue to be held and not be paid to the respondent till resolution of what he says is the impending court hearing. Three days later, and it's at page 16 of the second supplemental bundle, again, Mr. Wolanski on the 19th of August 2022, speaking to the complaints at DCBL, and he reiterates, first line, he says, the email I sent a few days ago asking if you would continue to hold the funds in the event that my chargeback fails and I instigate a money claim online application for unlawful enforcement. And I suppose that last line goes towards the point the ladyship raised, which is DCBL saying that they have acted lawfully. But Mr. Wolanski's position is obviously diametrically opposed to that. He's saying that they acted unlawfully. In that context, one might understand why the position is set out by DCBL at the time. On the 25th of August, and this is at page 14, again, this is a chaser from Mr. Wolanski, and he says, I was hoping you could respond to my query about what you will with the principal debt money do in the event my chargeback is not successful. So again, so that goes towards the point that he's actively asking them to hold the money pending the outcome of the county court claim. And again, he says, given that I will issue a claim in the county court for unlawful enforcement. So again, intimating he will bring a claim in his personal capacity. And then on the 27th of August, and this is at page 12 and 13, of the same bundle, email starts at the bottom of page 12, but the relevant passage is at page 13. Top of the page, he says, if that was the case, I would issue a claim in the county court for recovery of the full amount. There would therefore be a dispute between myself and DCBL, and I was querying whether the funds paid to DCBL would be transferred across to ABC. In this case, it speaks about funds remaining on hold.
It's all up to him to decide whether DCBL put the funds on hold, is it?
No, it isn't at all. But there's a
nor indeed is it up to DCBL. Aren't they supposed to pay the money to ABC?
Well, on that point, I take the learned friend's position set out in his skeleton argument, which I was going to turn to, but I can deal with it now.
Oh well, don't. If you're going to deal with it later, I don't want to take you out of turn.
I was going to put my best foot forward and then respond if that's appropriate. But
Of course.
I think, as the question has risen, my position will be: there's nothing that says that the monies have to be paid immediately, as it were. They must be dissipated to the creditor. Can't be spent anywhere else. But I'll agree with what my learned friend puts forward in his skeleton about that point. So, page 23 of this supplemental bundle, this is when we see the beginning of the agreement coming together. And it's on the 20th of September.
Sorry, I'm in the wrong page.
No apologies either.
Page 23.
Yes, yes, sorry, it's page 10.
10.
So it's the 20th of September when it appears, well, this is at least the first evidence that the second chargeback isn't resolved.
Yeah.
And this is from Mr. Wolanski to DCBL. And again...
So just pausing there, one might infer from that the bank had accepted what DCBL had said about the reason for the payment and the circumstances in which the payment was made. Would that be a reasonable inference to draw?
Well, it's definitely, the chargeback's definitely been defended because we've seen the defence that was put in on the 15th of August, or the 10th of August, I should say.
Yes.
And then that was the defence. So if it's not been successful, I couldn't push against the fact that whatever had been said by DCBL had been accepted by the bank,
Yeah.
or at least has formed part of their decision-making process. But I think one of the factual issues is what's happening with the money during this period. So between 15th of June to 20th of September, there's a reasonable inference to say that nothing could have happened because it was all subject to the dual chargebacks that were made, that were back
Yeah.
to back.
But so once the second chargeback had failed, is the position that DCBL should have paid the money over to ABC immediately?
Well, I'm not sure that there's any express requirement that says that the money must be paid immediately. As far as I can go on that point, it's that DCBL, in their capacity as the High Court Enforcement Officer, have to hold the funds for 14 days pursuant to the Insolvency Act,
Right.
in case there's a petition presented and effectively the defendant, ABC, gets a jump on the creditors.
Right. But 14 days running from what date?
Well, I would suggest that must be the date when the funds are actually available to them to dispense. So that would have been the 20th on these.
I see. But even if they've still got the money, is it theirs to use to settle a complaint made by an individual?
Can I roll back? Because I think
Yeah.
actually I've probably confused the issue.
Right.
I suspect my learned friends will be scrambling to respond to the position where I've said that the payment doesn't need to be made immediately. What my learned friend says, and which I agree with, is that it's not clear as Tribunal Courts and Enforcement Act does not expressly state that payments to the enforcement agent instantly discharges the underlying judgment debt.
Right.
The position that the respondent takes is that if the money isn't discharged by the debtor, then it must be the case that an enforcement power, the ability to collect the money, hasn't been discharged properly, as it were.
Sorry, just say that again really slowly because I'd like to take a note.
Maybe I'll do it, or maybe I'll change it round. Actually, I said all the right words in the wrong order.
Right.
Which is the
Right.
enforcement power is granted to the HCO
Yeah.
against the debtor.
Yep.
Their enforcement power allows them to take any goods, including money, which includes a bank payment,
Yep.
from the debtor in order to satisfy
Yep.
the writ. But there's a lacuna if the money is paid by a third party who is obviously not the debtor or either authorised or ratified by the debtor to make the payment.
Right.
And so whilst it's imperfect, that third party has recourse through further proceedings. Learned friend says unjust enrichment. It may well be that's what Mr. Wolanski was envisioning when he was saying that he would bring a county court claim. But there has to be a payment from the debtor in one form or another to discharge the debtor's debt. It can't be that money can be taken from anywhere. Because that would create a double injustice insofar as somebody who wasn't required to make a payment has made the payment, and the creditor, who may not receive the funds, hasn't received satisfaction of that debt. And I think what's being asked is, or what's being put is effectively, the remedy here is that everybody can sue the bailiff.
Sorry, by the bailiff do you mean the High Court
The
enforcement
High Court
agent
enforcement
or
the High Court enforcement officer
Yes,
who has the writ has to supervise the agent,
yes,
and that would then be the remedy
to sue the agent.
to sue the agent. So
Right.
the creditor would be able to sue, to sue the High Court enforcement officer, so DCBL.
Right, sorry. So ABC could sue
Mr. Williamson.
DCBL.
Yes.
Of course, Mr. Williamson and DCBL are different
Yes.
entities, aren't they?
Yes.
Because the HCO has to be an individual; it can't be a company. Right. Right.
And then the person who's wrongfully made the payment can also sue the HCO.
Right. So that's your
But that seems to be the only remedy for those who have made the payment incorrectly, should we say. I'll call it the incorrect payment, and those who have not received the benefit of the payment. And that seems to be an imperfect remedy to the situation. And it also bypasses, I won't go as far as to call it a doctrine, but the principle that whilst a third party can make payment, there needs to be authorisation.
You're moving on from this document.
I'm still looking at paragraph, the email of 20th September,
Yes.
which is at page 6, which is at page 10 of the second supplemental bundle, and effectively it repeats everything that's been said in the preceding documentation, insofar as it seems at this point we know that the chargeback has failed, but we're told, failing that, third line down, I'll be issuing either a money claim online application for recovery of the principal debt and fees because the enforcement officer broke the law, and that he understands, Mr. Wolanski understands, will give him the opportunity to claim for additional costs and compensation for suffering that myself and my son incurred. And so I've already made the point that it appears that actually can't be argued that this is a claim that Mr. Wolanski, whilst referring to himself as bringing it, is actually talking about 56 Fellows Road, because he's talking about what appears to be some kind of general damages for distress and anxiety that was caused to him personally, which obviously wouldn't be recoverable by 56 Fellows Road. And fourth line from the bottom, it starts with, in order to seek to avoid the issuing of a claim, I would once again welcome you to review the conduct of Craig Fishwick and reimburse me for the principal debt plus the fees. So in this case, we're talking about a reimbursement, but I make the point that one can't reimburse that which hasn't been paid, and one can't ask for a reimbursement if they haven't made payment. So the inference is that Mr. Wolanski is accepting he made the payment even up until the 20th of September 2022. And then at page 20 of this bundle, there's an email of the 30th of September. And it appears at this time that there's been an agreement between the parties, because Mr. Wolanski speaks to Steph Clements at the complaints of DCBL and says, "Thanks for getting back to me. Whilst I do not agree with all the contents of your review, I appreciate your gesture of goodwill to bring this matter to a close. I do intend to accept this and sign your attached agreement, but would like to have," well, it says Loke, but like to have a quick call with you to understand some of the terms which I do not quite understand. And if one looks at the bottom of that page, you can see the email that attaches the offer, and the attachment can be seen at page 21. And it's the last paragraph which is of relevance, because it identifies what's going on within the mind of DCBL at the time it enters the agreement, or in anticipation of entering the agreement. And we're told that dealing with the issue equates to significant time and resources, and that the EAC2 proceedings are also pending a listing at court. So not only are they investigating the claim internally, but they know there's something external which is fast approaching, and it adds to the expense incurred. And so in light of the above, they've made a commercial decision. And if one turns the page, there's some imperfect formatting, but it's a commercial decision to offer as a goodwill gesture the return of the sum in full and final settlement of this matter. And the matter must be the complaint, because this letter is only in relation to the complaint. It then says, in terms, on the basis that all complaint correspondence is concluded, together with withdrawal of the EAC2 proceedings that you have issued. So it puts the settlement agreement into some more context so far as it speaks towards what's being offered. There's the explanation. But what can be drawn from that interaction between the parties, between...
Can we put this bundle away now, or is there
Yes,
more
yes.
to come?
But to wrap that up, what I invite the court to find is, what can be inferred from that correspondence is that Mr. Wolanski hasn't ratified or authorised the payment as of yet. And that can be drawn from the fact that he continually threatens to make the county court claim in his own name, repeatedly asks for a return of the funds, and a Taylor Maloney friend says that one can't place too much emphasis on the terminology contained within the agreement, because it may mean something else. But it is of relevance that there is a personal request to return the funds. And at no time has Mr. Wolanski said that he had ratified the payment or had authorised to make the payment on behalf of the company. Nor is he asking for the sums to be returned to the company or on behalf of the company. At page 115 of the core bundle is the next relevant document. This is the agreement that you've already been taken to.
Before you take us to that, Mr. East, can I just ask you a question? I'm inferring from the fact that this is an extra supplemental bundle that this wasn't before the circuit judge. Is that right?
No, it wasn't before the circuit judge.
Why not?
I'm unable to answer that question. I can answer some of the question insofar as those who instruct me have had to try to obtain the documentation from DCBL, and I can go as far as to say this: permission was granted in relation to rely upon all of that documentation this week. That's not on Monday before this.
Yes, but I mean, does it satisfy Land and Marshall?
Can I return to that
Sure.
momentarily?
Sorry, I've just
No, it's not at all. I just need to.
And as the one who gave the permission, albeit that it wasn't opposed, I can't remember what the evidence was as to.
Well, Mr. Croot does take the court through in his witness statement. Mr. Croot was the person who made the application and provided two witness statements. He took the court through Land and Marshall at the time. So if I'm required to go through it, I shall. But I might submit glibly that, so far as it wasn't opposed, it was accepted that it fulfilled the requirement.
Okay.
And that's in his first witness statement in relation to that application.
We haven't got that, presumably.
It's not in these bundles, no.
All right. Thank you.
So the next document is the settlement agreement that arises, that is signed at page 116 on the 12th of October 2022. So that's 12 days after the last correspondence on the 30th of September, and we're just short of 4 months after the payment was made. If I invite the court to consider page 115, travel through much the same ground, but try to put a different spin on it to my only friend has trodden already. The parties are Simon Wolanski. He is called the debtor at the top of the page, but under the heading parties, he's called the complainant. And the agreement speaks towards the complainant. That can be seen at the end of clause 1, which is that sum will be returned to the complainant. And I won't again speak towards the relevance of the term returned to the complainant. I've already spoken towards it twice, which is it can only be returned if it's paid. And then at clause 4, it says this agreement is in full and final settlement of the matter. And the parties agree no further recourse will be sought by either party. Now, the appellant is not a party to this agreement, nor is the respondent. I ask the court to be mindful of that phrase, the matter, because I say that the matter can only be looked at as referring to the complaint made by Mr. Wolanski. And whilst there's reference to the county court claim number from which this all emanates from, and the writ, so far as the reference numbers are provided, that only relates to the fact that the complaint comes out of the enforcement of the judgment and the writ that comes from the judgment itself. If that hadn't occurred, then the enforcement agent would never have come into contact with Mr. Wolanski, and Mr. Wolanski wouldn't have made payment. And so it's simply trying to put into reference what the matter is, rather than speaking towards the external issues that are going on between the appellant and the respondent, and binding the appellant and the respondent, because of course the appellant and respondent are not mentioned within this agreement whatsoever. And then at paragraph 7, or clause 7 at page 116, the parties understand that there is no admission of liability in settlement of the matter, and such payment relates to the agreement only. As I say, the agreement is to return the amounts to the complainant. It doesn't speak about the debt having been discharged. I'll be referring to the first supplemental bundle now when we look at page 14. And we're looking at this document just to try to identify when some further correspondence was made. It was that document that was undated by Mr. Wolanski. So this is the application for a charging order on land. It's stamped as received. It looks like the 3rd of July 2023, but it's actually signed at page, or dated I should say, at page 18. What looks like to be the 2nd of June 2023. Now, in response to that charging order, the letter from Mr. Wolanski appears, and that's at page 20 of this first supplemental bundle. And we know that this letter comes at some point after July 2023, which is about 8.5 months after the agreement. And this is the first time that it might be said at its highest there's some evidence that a ratification of the payment has been made, although it's not in express terms, and that can be seen at paragraph 3, where it states, "It is our position that payment of the debt was made to DCBL bailiffs on 15th June 2022 and enclosed receipt for the same." But thereafter it speaks towards, "Due to the bailiff's behaviour, I was forced to make a complaint," and utilise a EACT form, and then the next paragraph goes on to tell us that to induce me to withdraw the EAC2 complaint, the bailiffs agreed to refund monies paid to them in full and final settlement of all ongoing litigation. And I say that just simply isn't the case. The agreement doesn't speak towards all ongoing litigation, doesn't speak towards the parties of this appeal. But importantly, nor does it say that it was effectively a compensatory claim for whatever damages that were going to be sought by Mr. Wolanski, or in anticipation of the payment of damages. And again, it uses the terminology refund. And so that's similar terminology that we saw during the 3.5 odd months of correspondence between the parties in June to September. And then, what is the objective evidence? I can say this, that there's been a ratification. It appears in the second supplemental bundle, and it's the last page. And this certainly didn't appear before the circuit judge, because it's dated 27th of January 2025, and judgment was given on the 5th of December 2024. And it says, under the heading, "It was resolved that the above transaction was retrospectively authorised, and that the payment by Simon Wolanski to ABC Block Management Limited was treated as being made on behalf of the company." I I accept what my learned friend says. We don't need a clear written resolution, although it's very helpful. But that terminology contained within the written resolution speaks directly against the authority having been given to Mr. Wolanski at the time he made the payment, because it speaks towards a retrospective ratification. So that must have been the case. It must have been the case that the ratification was given after payment was made. So to a certain extent, the argument that he had capacity and he had internalised this capacity within himself without having to articulate it or make it formal falls by the wayside, because the objective evidence is that several years after, 2.5 years after the event, it's being called a retrospective ratification. It's not in contention, but on the 28th of January, Mr. Wolanski made an application to the courts. It was the wrong type of application, but he was asking for the judge to change her judgment to show, rather than the money had been paid by himself, his personal capacity, that the money had been paid by 56 Fellows Road, which deals with the ratification point or the authorisation point. And the court's already seen that within the judgment, Her Honour Judge Boucher, she speaks directly to the point about retrospective ratification when she refers to Chitty, and it was the passage that seems to have been incorrectly transcribed. So he was aware of the issue that had occurred. So I say there's a peculiarity there that this document finds its way into existence after the event. And so the inference to be drawn is that the earliest point the court can, well, the inference to be drawn is at all times prior to the payment back of the sums, that Mr. Wolanski was acting in his personal capacity. The earliest time that there can be an inference was after the 5th of July 2023, that there'd been ratification. That was after the sums had been repaid. Within the authorities bundle at page 42, it's the case of Simpson and Egginson that came before the Exchequer of Pleas. It's marked at page 847 of the report. It's the black line on the right hand side.
I'm so sorry, it's my fault, Miss Rees. Which tab is this, please?
Sorry, within the bundle it is tab 10.
Tab 10.
And it just reiterates the rule that's already been voiced in the court today, which is that it's not sufficient to discharge, that the general rule as to a payment or satisfaction by a third person not himself liable as a co-contractor or otherwise has been fully considered in the cases, speaks towards the previous cases, and that the result appears to be that it is not sufficient to discharge a debtor unless it is made by the third person as agent for and on account of the debtor and with his prior authority or subsequent ratification. At tab 12 is the case of Smith and Cox. This came before the King's Bench Division, and at page 560 of the report, so at page 52, there's an interesting passage because it's particularly interesting for what the court says about the evidence in that case not supporting that a payment had been made on behalf of the debtor. And the court stated, "I cannot find the least evidence in the present case that, either as between himself and the landlord, or as between himself and the plaintiff, the defendant acted or purported to act, or regarded himself as acting, and I emphasise that, as the agent of the plaintiff. And the view I take of this transaction is that the defendant did no more than advance out of his own pocket to an elderly impecunious landlord money which he did not wish her to be without for any length of time. Of course, that's not particularly the case here in terms of why the money was paid, but it does have a certain resonance with the current matter, so far as there's no evidence to suggest that Mr. Wolanski ever regarded himself as having made payment on behalf of the respondent. And at tab 13, it's the case of Cantrad Limited, Lloyd's Bank, came before the Court of Appeal. And it's at page 58, the relevant passage is marked. I'd like the Court to consider the passage between F and G. And again, it speaks towards the absence of evidence that the bank's payment has been made on the customer's behalf or subsequently ratified by him will not itself discharge the company's liability to the creditor. And whilst not marked on the same page at paragraph J, the whole paragraph is of assistance insofar as it says that it's unnecessary in this appeal to decide the general question as to the circumstances in which another's debt may be discharged. But in the present circumstances, the onus is on the bank to set up any equity they assert to defeat their customer's claim for the return of his money. They may do so by evidence of authorisation or ratification of payment to a third party, but those features are missing in this case. And I say, whilst not on all fours in terms of it was a case about the return of money, the evidence about ratification or authorisation is missing in this case. And so the question, and I don't think there's any contention about it, that remains is when is it that a valid ratification can be made?
Just if you're leaving that point, you're moving on to the effect of the October agreement, are you? Or not?
No, I'm simply saying that really it is the simplest point, which is, and the court's already made it.
You say no evidence.
If there's a ratification after the event, the clearest evidence that there was ratification is the letter of the 28th of January, or the resolution, the written resolution.
I mean, this is right, is it? You lose if either A, Mr. Wolanski authorised the payment on behalf of the company at the time,
yes,
or B, the money was not returned. Because if the money was not returned, and then it would be open to Mr. Wolanski to ratify later anyway. And he did.
Yes. Well, then I'll move on, because I don't think I need to take the court to the fact that the proposition is ratification has to take place before the money is returned.
Actually, if you're going to show us authority, then do that.
Certainly, I'm grateful. It's at page tab 11. Case of Walter and James, and we're at page 49. It says it is competent for the creditor and the person paying to rescind the transaction at any time before the debtor has affirmed the payment and repay the money, and thereupon the payment is at an end and the debtor again responsible. So they are really the thrust of my submission. Some comments upon the position the learned friend takes, which I've dealt with somewhat confusedly, is that the lacuna in the reasoning with regard to the payment is that the logic being applied is that any payment to the bailiff, I'll call him the HCEO appropriately, or the agent I should say, instantly discharges the debt. So it requires the court to put out of its mind the realities that circumstances can occur in which the debt's being recovered from the wrong person or the enforcement powers being exercised against the wrong person. It effectively says you don't have to worry about the circumstances in which payment is made and by whom it is made, which cannot be correct. Now, to bridge that gap, the appellant, speaking towards the agency argument, relies upon the reasoning set out within William Henry Gregory and Thomas Cottrell, speaks towards it in his skeleton arguments, and it can be found at tab 9. The marked page is at page 038.
So the payment to the agent was payment to the sheriff.
Payment of the agent was payment to the sheriff, but in this case, effectively, the background to the case is it's not on all fours. It doesn't appear to be congruent with the index case, insofar as the issue in this case was the money mysteriously goes missing, never gets to the creditor, but they say that the debt's been discharged. That's not the case here. The money was always where the money was. And there's no argument about who was paying the debt in the case of Gregory and Cottrell. That wasn't being forwarded as to whether or not somebody was paying the debt on behalf of another person and they had authorisation or ratification. It was simply a straightforward argument about misappropriation of funds and what that meant if an agent had collected. And to test the logic, arguably, there's a question to be asked about what would have happened if the chargeback had been successful. So it's a hypothesis. The money had been collected, there had been a chargeback. If that had been successful and the money had to be returned to Mr. Wolanski, it can't be the case that the underlying debt had been discharged simply by the collection of the funds that had been held. And in that respect, the learned friend has not spoken about it, but speaks about it in his skeleton argument, that the policy behind making the collection agent, the officer, responsible is a public policy argument as to the protection of the vulnerable debtor, so that they can't just misappropriate funds. But he says that that is predicated on the basis of provided that the debtor has paid the enforcement agent. And of course, it's the issue that the respondent puts forward is it doesn't appear that the debtor did pay the enforcement agent, because Mr. Wolanski argues that it was he that paid the enforcement agent. So the public policy argument falls by the wayside. It's not the debtor who's being protected. Then, two more points. The court's already touched upon this at the beginning of the young friend's submissions, which is, what if somebody pays it because they're in fear or they're scared? And Mr. Kessler says in his skeleton argument that what the court is effectively being asked to consider is, if this was a payment, it was effectively Mr. Wolanski making a gift, and that would be an absurd proposition, that he was simply gifting the money, and of course the legal meaning of the gift being separate to what a gift might mean in normal parlance. But that ignores the contemporaneous evidence that Mr. Wolanski's put forward when he makes the complaint. And there's two documents I invite the court to look at. We've looked at them in relation to what he was saying about who had made the payment. But in the second supplemental bundle, you see the email of the 20th of June.
Page.
Oh, apologies, it's, my lord, it's page 23. So this is the email of the 20th of June, and it's midway through the page, and it's the short sentence that starts with, "I was manipulated into making the following payment." And then at page 24, part of the same correspondence, third paragraph, the sentence starts with, "As a result of panic, fear, and having no opportunity to contact advice to challenge the information being given to me, I felt I had no other option than to make a payment personally." And then I asked the court to look at the EAC2, which is contained within the first supplementary bundle. And it's at page 8, we're looking at the continuation page. And it's effectively the beginning of every paragraph. First, says, "I felt extremely vulnerable. Now I had no means to communicate." The second paragraph, "I was also shocked that my phone had been taken with personal data on it." The third paragraph tells us that his son was in distress and crying, and this further added to the serious harm and distress that the whole episode was causing Mr. Wolanski. The fourth paragraph begins with, "I was too scared to leave my flat." And the fifth paragraph begins with, "In fear of the impending break into my flat and the impact this was having on my son, I then felt my only option was to pay the funds using my own personal account." And so actually, it appears that rather than making a gift in the normal parlance of the word, it was, in effect, the motivation was a type of coercion that was being exercised upon Mr. Wolanski, without taking it any further than using that word in its normal parlance. Can I be of any further assistance?
Yes. If we go back to the I suppose we're in the supplemental bundle. If we go back to what was before, well, the district judge and then the judge, can I be clear about that? There's Mr. Wolanski's statement at tab 6, page 9. Or is that, I assume that was before the district judge.
I believe that was before the district judge. It's dated the 5th of August 2022.
So actually that would be long before the hearing before the district judge with which we're concerned. That would be back in 2022.
No, this is...
No, this is the complaint.
This
sorry,
is the
yes.
complaint, sorry. This
Yeah.
is the complaint accompanying the EAC2.
So sorry, so in terms of the evidence before the district judge from Mr. Wolanski,
That
the district judge we're concerned with
That's a supplemental bundle, page 28. So the first supplemental bundle.
Yes.
And that's dated the 24th of January 2024.
Yes, I see. And that's the one which, as Mr. Kessler was pointing out, includes references to the debt having been paid.
Yes.
In paragraphs 6 and 16. Can that constitute evidence of authorisation or ratification?
Well, it's in very similar terms to the letter that the court's already seen that comes sometime after the 5th of July 2023, so I assume comes before this witness statement. In fact, it's almost identical insofar as where it says the judgment debt was paid in full to date DCBL. And that the judgment debt was settled in full by the claimant. It may constitute ratification, but I think the highest I can say is it doesn't expressly state how the ratification took place or there was an authorised payment, and in any event, it's too late because the money's already been returned.
Now, one might say, actually, there was an issue of fact between the parties. On Mr. Wolanski's case, he says, well, yes, there was authorisation or ratification, and you say, no, there wasn't. Issue as to that. There obviously wasn't any oral evidence. I'm not sure there were any real submissions as to that before the district judge, as opposed to Judge Boucher. What does one get from that?
But the issue that it's never been determined as to whether or not there was ratification or authorisation, I suppose, is the question. All of the contemporaneous document, what does one get from that? One can't get anything from that, I would submit, because all of the contemporaneous documentation that one would have hoped had been before the district judge and the circuit judge appears now before this court, and it was never argued prior to coming before the district judge that ratification had been taken place or had taken place.
So Mr. Kessler says, well, look at the skeleton argument. You weren't disputing that. Should we look at the appellant's skeleton argument to see whether it was suggesting ratification or authorisation?
Apologies, my lord, is that a question? You're asking me whether
yes,
or not I agree that
we looked at your skeleton argument in this context.
Yes, well, I would say that the difference being between the skeleton arguments that are prepared now for legal argument and the skeleton argument prepared in relation to those previous hearings is at most as extraneous evidence that doesn't directly point towards the arguments that were being made by the parties, or at least the evidence that was being put forward by the parties, but it was just articulating the position that could have been argued. I think there's a difference between what was in the mind of the parties at the time and then what could be argued 18 months later before the district judge, when effectively the argument was whether or not the payment, very similar state, if the payment had been discharged and what the effects of the settlement agreement was.
And just for completeness before we break, I see I see Mr. Wolanski's skeleton argument was at is it supplemental bundle tab 13, page 34. And so his submissions are in paragraphs 7 and 8, really, aren't they?
Yes.
Yeah. So you've completed your submissions,
yes,
subject to any thoughts you have by 2 o'clock, and then we'll hear from Mr. Kessler in reply.
All rise if you